Last Friday, the Supreme Court of Canada released a decision that provided much-needed clarity on employment law in Ontario and across the country generally. This wrongful dismissal case, David Matthews and Ocean Nutrition Canada, clarified if and when additional compensation, such as bonuses or long-term incentive payouts, are owed to employees who are either constructively dismissed or terminated without cause from their employment. The Supreme Court affirmed the approach Ontario courts have taken in interpreting bonus entitlements during the notice period. The Supreme Court of Canada confirmed that every employment contract has an implied term of reasonable notice built into it. If reasonable notice of termination is not provided to an employee, then the employer is obligated to pay out damages. Generally in practice, this damages payout is pay in lieu of notice and is often phrased as a separation payment or severance package. The issue here is that if an employee is entitled to some other additional payout that may vest during that notice period. So say, for example, an employee is entitled to 10 months notice and they have a big bonus payment that would become due and payable in the 9th month. The employee is terminated, they're paid out for the 10 months that they would have gotten in terms of salary, and they go on their merry way. Well, on that 9th month, when the bonus becomes due, the question is the employee owed that bonus as part of their severance package or separation payment, or are they only owed their salary? The Supreme Court clarified that yes, in fact, that employee is owed the bonus payment unless the employment contract or the bonus plan or some kind of additional either policy or program that the employee has signed on or consented to takes away that right. So you'll often see contracts or bonus plans that have the requirement of active employment or full-time employment. The Supreme Court has confirmed that this language has little meaning in employment law and that the employer has to be especially careful when drafting that language in order to exclude an employee from entitlement to a bonus. So it's not enough just to require full-time employment, and it's not even enough to say, well, if you're terminated without cause, you're not entitled to this bonus. Takeaways are, if you're an employer, you should absolutely get an employment lawyer to review not only your employment contracts, but any kind of bonus plan or long-term incentive payment plan that you might have in place. You need to have very precise language in order to exclude employees from collecting on any kind of bonus payment if it falls within their notice period after they're either terminated or constructively dismissed. If you're an employee and you either quit and sue for constructive dismissal or you're terminated without cause and you're provided some kind of severance package, it's always worthwhile to have an employment lawyer review that package, not only to see what your entitlements are in terms of a notice period, but whether you're entitled to any kind of additional bonus payment, compensation, something like that that would be due and owed if that amount falls within your notice period. The lawyers at Kelly Santini in our employment law group are always happy to help, so please feel free to give us a shout anytime.